framing it. Given the Omicron variant's surge, even though it appears maybe it's going down a bit, for the safety of the participants today and the safety of court staff, I noticed this case as a Zoom argument. Attorney Johnson-Karp, do you have any objection to that today?
No objection, Your Honor.
Attorney Burnett, any objection to holding this hearing by Zoom?
I have none.
Attorney Dean?
No, thank you.
Attorney Boylan?
I appreciate it, and so no objection.
And Attorney Lenz?
No objection, thank you.
Okay, with that, we're going to proceed with the motion to intervene. I have read the submissions by the parties, including the initial brief and the filings by the defendants in this matter prior to today's hearing. So with that, Attorney Lenz, this is your motion. I'm going to give you the opportunity. Actually, before we start, Attorney Johnson-Karp, are you objecting to this motion to intervene in this case?
We are not, Your Honor.
And do you wish to have any, take a position on the record, or are you just here to spectate today?
Our position is simply no objection to the intervention.
Okay.
But I don't need time to argue today.
Okay.
Thank you.
And also, before we proceed, Attorney Lenz, someone just entered the waiting room by the name of Mel Barnes. Is that a party in this case? That anyone?
Mel Barnes is my colleague. It's at Law Forward and would be counsel for Voces de la Frontera Action.
All right, I'll admit Mel Barnes and make the appearance. Attorney Lenz, Mel Barnes is from your office and with Voces de la Frontera. With that, Attorney Lenz, this is your motion. You may proceed.
Thank you, Your Honor. Voces de la Frontera Action set forth its prima facie case in support of its motion to intervene in our initial brief. So I'll spend my time in argument today responding to the various arguments raised by the defendants in their filings over the past couple of days. And I'll begin with the response from Speaker Vos in the Assembly. Speaker Vos goes through the elements with the exception of timeliness, though that's addressed by Mr. Gableman's response, beginning with whether or not Voces de la Frontera Action has a sufficient relationship with the case that's pending before the court. As the court stated in Helgeland, there's no specific test for this element. As with most things in intervention, it's viewed with a broader, more pragmatic approach. Even, however, if you accept the test that's proposed by the defendants, that there needs to be a direct and immediate relationship, we believe that Voces de la Frontera Action meets that requirement. First, Voces does have a direct and immediate relationship to the case that's before the court. From the outset, this case has been about the rules that apply to the various subpoenas that have been issued by the defendants. This includes the defendant's argument that the court has absolutely no authority to review those subpoenas or to review the legislature's actions in its investigation. This is a position that some of the defendants have renewed most recently in their petition for an interlocutory appeal at pages 13 through 17. The strongest example of Voces' interest in this case is should this court or a subsequent appellate court accept the defendant's position on this matter, that would dramatically reduce Voces' ability to challenge the subpoena that they've now received and would obviously impair their ability to protect their constitutional rights. Conversely, should the court accept the plaintiff's views that the subpoenas are unenforceable or are subject to the normal requirements of due process, that would also inform the subpoena that's been issued to Voces. Voces therefore would stand either to lose substantially or to gain substantially from any judgment that this court or a court of appeals may issue. As the court stated in Helgeland, this test must be viewed in light of the purpose of the intervention statute, including disposing of lawsuits involving as many apparently concerned persons as is compatible with efficiency and due process. I don't believe there's any question that should this court dispose of the lawsuit by finding that the subpoenas that have been issued are unenforceable under one of the shared positions between the plaintiffs and Voces, that would also dispose of Voces' action. Instead, the defendants appear to be inviting more separate lawsuits that would generate confusion in the law potentially, or require duplicative briefing and hearing by courts. and additional delay. It appears to be contrary to their stated interest in a timely disposition, as is their sudden and extensive demands for discovery that come up in Speaker Vos in the Assembly's brief. We can address those, but those demands seem inappropriate given that this is an action for declaratory judgment. The defendant's arguments also are premised on a simple misunderstanding, I believe, of the shared arguments between Voces and the WEC. We do not agree that we only share the one argument under 1331. Instead, both Voces and the WEC and Administrator Wolf have challenged the subpoenas as not having a sufficient relationship to a legitimate legislative purpose. On
that point, the WEC did concede, or seemed at least on the record for purposes of that motion, that the investigation of the elections was a legitimate purpose.
Absolutely, Your Honor, and we were certainly aware of that. That continues, however, be a live claim and is a live claim in the amended complaint. I'll certainly defer to WEC on their position, but my understanding is that argument is being reserved in case this investigation takes yet another turn into an area that lacks legitimate legislative purpose. But in any event, it continues to be a count in the complaint. Similarly, we share the argument that the subpoenas as issued are unconstitutionally and wildly overbroad and vague as to what exactly is being demanded. And a determination on any one of those factors would have an immediate and direct effect on the arguments that Voces has put forward before the court. Similarly, we don't agree with the defendant's arguments, perhaps obviously, that the subpoenas are not related. These were all subpoenas that are issued as part of the same investigation, and particularly the subpoena that is now included in the amended complaint, or the proposed amended complaint, directed to Ms. Linsky, to Sarah Linsky at WEC, is in fact, it appears to be a carbon copy of the Voces subpoena. They share the exact same demands for documents. But in any event, these subpoenas all follow generally the same process. They're being issued by the same defendants and request largely the same body of documents and information. Getting to perhaps another element in the Hugelin test, or in the test under 80309 for mandatory intervention, non-participation in this case would directly threaten VDLF Voces' rights. And that's, again, the clearest example is what the defendants are trying to do in the Court of Appeals. If the Court of Appeals were to adopt that argument, that would be binding on a subsequent circuit court in which Voces may have to appear if the motion is denied. And Voces would not have had an opportunity to participate in that appeal or in any subsequent appellate proceedings. At a minimum, these issues are sufficiently related to meet the test under 80309. Even without the Court of Appeals issue, however, stare decisis, the fact that this court may issue one ruling that would not be binding on a subsequent circuit court, but may inform a circuit court, is a proper consideration under Hugelin. It's not that the court needs to just disregard the effect of stare decisis in determining whether the arguments are sufficiently related. That should be considered because this is fast-moving litigation, and the effect of a decision of this court on a subsequent court would probably be obvious that once a determination is made as to the rules that are going to apply to these subpoenas, that would inform any subsequent litigation in which Voces may be involved. I'll move to the test for permissive intervention and then maybe back up to the timeliness argument because that was raised later. And this also overlaps with some of the adequate representation arguments that the defendants put forward. I don't think that there's an argument that WEC can represent Voces' interest. WEC and Administrator Wolf would have no standing to challenge the subpoena that's been issued to Voces, would have no ability to obtain a judgment from this court or any other court that would determine the rules that are applicable specifically to that subpoena.
But I think what the defendants are arguing is that if these subpoenas are the same as you are arguing, then WEC can represent your interest, because if the subpoenas are declared constitutionally invalid, that would apply to the same subpoena in your situation.
Respectfully, Your Honor, I don't think that a judgment from this court on the issues of the WEC subpoenas would be sufficiently binding to protect Voces. If this court were to, for example, find that all subpoenas issued by the committee and Mr. Gableman were unconstitutional, that might provide some degree of protection. But
I don't think I have the authority to do that.
And I believe that that's why we believe that Voces needs to intervene, so its subpoena can be put squarely before the court, and any judgment could also grant the relief that Voces is requesting. And WEC simply cannot do that. They would not have standing to challenge our subpoena. To that end, in various arguments, the defendants say or imply that this would result in undue delay, and that's simply not the case. As the court's aware, there's no scheduling order in this case currently, and as far as I'm aware, no party has requested a scheduling order. We are not requesting that the court revisit any of its prior rulings, either its January 10th decision on the motions to dismiss or the preliminary injunction. We did not file for a preliminary injunction. We're not asking that the court re-examine those proceedings in any way. We don't believe that this should result in any sort of additional discovery. This is a declaratory action case, and I'm not sure what that discovery would produce. And the alternative that the defendants are suggesting would be a new lawsuit starting from the beginning with additional pleading, answer, perhaps motions to dismiss. And
or they're suggesting you join the Waukesha County lawsuit instead of this lawsuit.
Yes, Your Honor, and that suggestion is unusual. The Waukesha County lawsuit's an enforcement case against two mayors under a completely different statutory provision in which there's no action for declaratory relief. There's no action for injunctive relief. It's a case that Mr. Gableman brought against the mayors to compel their depositions or put them in jail. There are really no shared issues. I mean, the issues of the validity of subpoenas is shared, but procedurally it's in a completely different footing. And there's also no reason to believe that intervention in that court would be more appropriate as opposed to intervention in this court. And I'll wrap up with maybe just the timeliness argument. I think even by the most narrow reading, Voces had 11 business days to respond to the subpoena between the date it received it and the date it filed its motion to intervene, which was also the purported return date for that subpoena. On its face, that appears to be as quickly as a party can be expected to act. Voces had to retain counsel, had to determine what it wanted to do, had to prepare and review its papers prior to filing. Mr. Gableman, who's the only party who has suggested this was not a timely motion, cites no authority that 11 days is too long. However, there are cases mostly out of the federal court that find the opposite. Just in my review this morning, I found U.S. v. City of Chicago, 870 Federal 2nd 1256, finding that 46 days was not too long on a motion to intervene, and United States versus Kemper Money Market Fund Incorporated, 704 Fed 2nd 389. Those are both Seventh Circuit cases, one from 1989, one from 1983. In Kemper Money, the court also found 25 days was timely and reversed the district court's finding on that. I'll also point out that the defendants in many ways control the timing of this case. They were the ones who determined when to sign and serve the subpoena to Voces. They chose to do it during the holidays and, over the Martin Luther King holiday. And to now say that the motion was untimely, I think is an unfair proposition. The defendants also apparently agree that Voces did intervene prior to them filing their motion for an interlocutory appeal. At the core, Your Honor, and I'll wrap up here, the court's being asked to make important decisions as to the nature and scope of these subpoenas and what rules should apply in this investigation. And that now directly affects Voces because they're the recipient of one of these subpoenas. They don't particularly want to be in this case. But so long as those questions are before you, we believe we're a proper party to provide advocacy on behalf of our clients. And because we're seeking much the same relief as the WEC and Administrator Wolf. So I will end there. Thank you.
Thank you. Attorney Burnett, I'll start with asking, are you conceding, you didn't argue it Vos and the Assembly did not argue it in their brief that this was an untimely motion. Do you concede that it's at least timely for purposes of this hearing?
In my view, it is, Your Honor. I think the timeliness issue is a distraction. I think La Frontera has more difficult issues to surmount than timeliness.
Okay, you may proceed.
Thank you. I'm going to try to follow Mr. Lenz's argument as he's expressed it. The first comment that the intervener makes is that there may be some question about the test to be applied, if I gathered that correctly. The Helgeland case makes that test explicit at paragraph 45. The court indicates, quote, there must be some sense in which the interest is of a direct and immediate character that the intervener will either gain or lose by the direct operation of the judgment. A movement may intervene as of right when the movement needs to protect a right that would not otherwise be protected in the litigation. So that says two things. Number one, they need a proverbial dog in the fight. If this judgment will not affect the intervener's interests, they have no right to intervene as a matter of right. And that makes good sense. The second thing they have to show is that that right is unprotected if they are excluded. Now, in this particular situation, there's been considerable emphasis on the Helgeland case, and that case is very informative and instructive. In that particular case, the Supreme Court denied the right to intervene. It was not unlike this case. Municipalities tried to get involved in a litigation pertaining to benefits owed to same-sex couples. And they said to the courts, if you don't let us in this case, our financial interests will be affected by virtue of the precedent it sets. And the courts...
That's not really parallel to what's going on here, Attorney Burnett. That was a completely separate issue of whether anything having to do with the state's involvement in the, I believe it was the domestic partner benefits, would affect the municipalities on its face of that case. What's different here, at least in my reading of the intervention, is that Voces was served with essentially the identical subpoena, except for obviously name change, same location, same request, that they would be seeking the same relief if they filed their own action in court, that they would also be essentially filing this lawsuit against the same defendants. And that's where I think it deviates from your analysis of saying that case is similar.
Let me offer 2 points of view on the court's observation. First of all, these are not the same subpoenas. In the WEC case, the special counsel and the assembly have requested public records from a public administrative agency. In the La Frontera case, the records are requested from a private entity that's raising First Amendment issues. The second point is the most important one. In Helgoland.
But doesn't that point there also support that the WEC cannot represent the interests of Voces? Because one of your arguments is even if they meet the requirements, WEC is able to represent those interests in this lawsuit.
The second point is slightly different than representing the interest. The courts are not requiring that there be a privity in that particular setting. The courts are simply saying the arguments the Department of Justice presents, will they adequately represent La Frontera's points? You don't need two people arguing the same thing in one lawsuit. So the first question is, does La Frontera, is the judgment this court enters about WEC subpoenas going to adjudicate rights that La Frontera possesses? The short answer is no. Helgoland says the fact that La Frontera might have a common legal argument does not justify intervention as a matter of right. They have to have a common legal interest. And in the municipality's situation in Helgoland, the fact that they had a financial interest that would be implicated in the adjudication wasn't enough. So too here, the fact that La Frontera is not a party to WEC subpoenas is directly analogous because the municipalities were not a party to the contract that was at issue in that particular case. So I think Helgoland lends great credence, and it is almost directly on point. The second point that's been made is that somehow or other discovery wouldn't be appropriate in a declaratory judgment action. There's been no rule cited for that notion, nor is there any rule that would support it. A declaratory judgment action is no different than any other lawsuit.
I heard him say that he wasn't sure what discovery would be needed. I don't think he said it was precluded or would not occur in this case.
Yeah, and I've not formulated any discovery plan if intervention occurs in this case, but one of the things is La Frontera's claim that they have a First Amendment right to refuse, a privilege to refuse this information sought. That need not be accepted on faith at all, and inquiry is perfectly appropriate into what La Frontera does that they claim there's a First Amendment right about.
We're getting into what you see as the merits of their claim versus the intervention. So let's stick to the point here.
That's right, because the notion that discovery somehow or other is inappropriate in a declaratory judgment case where a First Amendment's been raised is front and center.
Well, yeah, I'll just say for the record that obviously if discovery needs to be conducted, it will be conducted. So I'm not making any blanket ruling that there's no discovery in a declaratory judgment action or in this declaratory judgment action.
And the overriding point about that is that this doesn't promote efficiency, it promotes delay, because with discovery comes delay. The third is that the idea that a legislative purpose has not been conceded. The Department of Justice in the last hearing acknowledged that a legislative purpose was fulfilled here. The fact that further efforts might somehow or other undermine that doesn't make intervention now appropriate because the issue is plainly not right. I'm just going through my notes. The idea that WEC can't adequately articulate this argument that the two entities share in common, I think is unfounded. There's been no suggestion that whatever WEC says on a critical criticizing the use of subpoenas or how they pertain to Section 1331 goes unarticulated if La Frontera doesn't intervene in this case. I don't think has any basis. The last issue is the most important one, and that is the delay that will be incumbent in this. This is a legislative investigation of an important issue, and the legislature has a limited term. The longer this matter drags on, the longer it is complicated, the more legal issues that are interjected, the more difficult it becomes to conclude this investigation. And if any legislation is appropriate, to introduce it.
Shouldn't a constitutional challenge be something that should essentially rise above any desire that the investigation be concluded rapidly enough so the legislator can act on it? I mean, these are serious issues and infirmities that have been raised by the complaint, and I'm not saying that ultimately those are going to bear out, but at least for purposes of the complaint, they're alleging serious deficiencies in constitutional issues. And to say the court should hurry along so that the legislature can keep to a timeline in this investigation seems a little out of balance given the issues in this case.
Well, the Constitution is important for purposes of conferring jurisdiction on the court. But the fact that a constitutional challenge has been raised doesn't make the delay any more justified. The whole point of this is that the constitutional issue is unique to La Frontera. The challenge to 1331 and the timing and location and the party questioning the subpoena are all matters of a legislative investigation that the separation of powers indicates belongs to the legislature and excludes the courts from. So the single issue that La Frontera claims in common with the Wisconsin Elections Commission is beyond this court's authority to address. It is the constitutional issue and only the constitutional issue that the court has the authority to address. And that constitutional issue is completely unrelated in these two subpoenas.
This is the arguments that were made on the initial briefing that I've already decided and that the parties have brought an interlocutory appeal on. So I don't really think that those are relevant for purposes of making a decision on intervention. So unless you have anything else, I'll let Attorney Dean present his argument.
They're relevant to the point that they are pertinent to La Frontera's effort to interject itself into a litigation and raise issues that are beyond the court's jurisdiction to address. The important point is the only issue they raise is something they don't have in common with the Wisconsin Elections Commission. So short of that, unless the court has any questions, I'm through.
Okay, Attorney Dean.
Thank you, Your Honor. I appreciate Mr. Burnett indicating that timeliness was not an issue. It is certainly an issue for the Office of the Special Counsel, and I would propose that there is a distinction between promptness and timeliness. I take no issue with the assertion that Frontera Voces was prompt in responding. 9 days is certainly reasonable. The amount of retained counsel, put pleas together, and so on. But whether it's timely, to me, is a different question. if someone through no fault of his own discovers that a party might otherwise qualify for intervention, but then notifies the court during closing arguments of a jury trial, while the party proposing intervention might have acted promptly, the intervention itself certainly would not be timely. And
well, that's far afield of the situation we have here.
Right. I'm just giving the example, an extreme example to illustrate the issue that promptness is different. And even though everyone else has said timeliness is not an issue, the fact is now we have been talking for 5 or 10 minutes about the delays incumbent, and that was the point of my raising the timeliness issue. In this case, certainly the response was, or the motion was prompt, but under the circumstances, it does engender delay, which I make the distinction that through no fault of proposed interveners is not timely. They have
You said you make the distinction. Do you have any case law to support your different interpretation of timely versus prompt?
Not that I'm seeing. I'm preserving my record.
All right.
All right. Then I think two things that have probably relate to virtually all of the different elements that have discussed. I believe Mr. Lenz indicated this is only an action for declaratory relief. It is not. Count 1 of the complaint is for violation of free speech and association rights, and the prayer for relief, item D, asks for award of a reasonable attorney's fees for VDLFA's work to protect its constitutional rights under 42 USC 1983 and 1988. This is, in fact, a proposed intervention for a civil rights action. I believe most of the attorneys on this, if not all, on this call, all are actively engaged in Section 1983 claims. And if, in fact, that claim were admitted and brought, a special counsel would have every right, as would all of the other parties, to remove the action to federal court. And in the end, who knows what would happen, but it's very possible the federal court would end up this federal court tail would end up wagging the state court dog if Frontera is allowed to intervene on these claims. I can speak with some authority on the Helgoland decision because I represented the municipalities in that case, and we lost 4-3. The issue was not a contract issue per se. It was, in fact, that the contracts in which all of these municipalities, and in fact every government agency which chose to participate in the state health plan, as a part of its contract was the state statute which was at issue. And there was no question that in Helgoland that a decision, had the plaintiffs prevailed, that decision would be absolutely and completely conclusive against the interests of the municipalities because it was a matter of state statute. And that was the critical issue. And Mr. Burnett was 100% correct. The preclusive effect against the municipalities was certain. There was no other opportunity for the municipalities in any way to challenge that decision. Yet they were denied intervention for the grounds that Helgoland stated. And in this case, there's clearly, if proposed interveners don't remotely approach that level of certain prejudice, if intervention is denied, they can bring a separate action in a separate court. The fact that there might be grounds to intervene in a walk-show action is really irrelevant. They can bring a separate action in a separate court anytime they wish. To intervene in this case is simply not, as a practical matter, do not meet the requirements for intervention as a practical matter. Everyone has talked about delay, and I also have the unique experience of having litigated Barland 6 years ago when the predecessor to the current plaintiff, Weck, brought a secret enforcement action against Governor Walker and about 30 defendants. A number of those defendants attempted to do exactly what Frontera is attempting to do in this case, bring a separate action to enjoin or preclude that or delay, intervene in that investigation by WEC and by the District Attorney of Milwaukee County. That the federal courts in that case, as they would in this case, ruled that because there was an ongoing investigation by the state agency, that these defendants had no standing, could not bring their own separate 1983 claims to disrupt that intervention. In fact, based on Younger abstention, they remanded to they denied these efforts and directed that the investigation by the Election Commission's predecessor, the Government Accountability Board, that they were able to continue with their investigation unimpeded by 1983 claims, attempting to bar its progress. The only reason that that investigation stopped was that, unknown to us, I had also, and Attorney Bob, whose firm is also appearing on behalf of Special Counsel, in 2010, we had commenced separate litigation, challenging the constitutionality of the underlying statute. We prevailed in, I think, 2014 and 2015. That effectively, then in state court, ended the ability of the GAB to proceed with that investigation. My point being that given what went on in Helgoland, what went on in Barland with the predecessor of WEC, the special counsel has every right to continue this investigation. If in fact Frontera chooses to bring a separate action to attempt to impede or preclude that investigation, it will meet with the same fate as the targets of the investigation did in.
I don't know that that's a point that needs to be made for purposes of this hearing. Let's stick to the factors and whether you believe that Voces has met them. Whether they're going to ultimately prevail isn't before this court today.
Right, but my point is I understand, I'm not arguing the merits, I'm simply saying that the merits will on their intervention would be delayed pending the investigation. That's the point, would have to wait. You raised the argument that don't the constitutional issues override the investigative issues.
I didn't say override, I said they're important matters that should not, should they be hurried through the process because of a legislative session potentially ending. That was my comment, not that they're more important.
Okay, and the reason I brought up these other situations was because in the experience of the predecessor to this very plaintiff, those constitutional issues took second seat or took a back seat to the progress of the investigation itself in that situation, and that was my point for raising those cases. I would also note that at the core is the alleged similarity of the facts of the interest. That's what, in one sense, runs through and perhaps is a determinative factor. Analogies are dangerous, but I'll make one anyway. Let's say a party sues an auto manufacturer for products liability, and a second moves to intervene. It's the same manufacturer, it's the same investigation here. It's the same kind of claim, products liability. It has the same legal arguments, the same legal theories. But the problem is the second is for a different model car, different parts, different drivers, different facts and circumstances about the accidents. These subpoenas are not the same. The subpoena to WEC is against a government agency for very different records. The subpoena to Frontera is to a private agency, not for the same information. It's for information that Frontera owns. They're different parties, and not just different parties. One is governmental, one is private. They're completely different records. And as the court probably is aware, in terms of response to records requests, those analyses proceed in some cases record by record by record. to.
I'm sorry to interrupt you, Attorney Dean. If there's no motion in the courtroom for a period of time, since I've been listening, the lights go out. So give me 1 second so I can turn them back on.
I'm sorry I had that effect.
Sorry, I've now pushed the magic in session button, so we should not have that problem again. Go ahead, Attorney Dean. My apologies.
Okay, thank you. And I'm just to wrap up here, I've mentioned untimeliness. I just talked about the relatedness of the claims. I've already mentioned that disposition of this action does not impair Vocus' ability to proceed. Of course, it can bring a separate action, whether it's in the Waukesha County venue or in some other venue. And obviously, to the extent that Vocus has any interest at all, I would mention that those I've just obtained, and I can provide them if it matters to the court or matters to the council, that in the Waukesha County action, the construction of Section 1331 has been raised, and actually raised by Attorney Mandelman on behalf of the mayor of Green Bay. So that particular issue, while it's similar, it can certainly be raised and is raised in other venues.
Why is Waukesha County any better equipped to handle this claim than this court in this litigation?
Oh, I'm saying not necessarily that they're better. I'm just saying there's another venue in which Vocus can pursue the relief.
Well, I understand that, but my question is why not this court if that is the issue for Voces to pursue? Because 1331 has been raised in this court as well.
Oh,
and this action was filed before the Waukesha County action. So why is that a better venue, in your opinion, or a better alternate place for Voces to take its claim?
Oh, my argument is not that it's a better venue. My argument is that I was to the last factor, that because that's been raised there, it's also been raised here. The Attorney General is more than adequate and certainly represents and has every motivation to raise exactly the same arguments and the same issue as Vocus would raise if it's intervened. And if you want to go back to Helgeland, of course, and all of the other case law, the fact that someone else even wants to make a different argument in pursuit of the same objective is not determinative on a motion to intervene. But in this case, the Attorney General is in fact and WEC are in fact making exactly the same argument on exactly the same issue that Vocus proposes. So there's no Voces interests are certainly adequately represented. On the permissive intervention, again, once as believe it, both the Assembly and Special Counsel have argued once adequate representation is present, permissive intervention drops out. Let's see, was there any? Yeah.
I believe you made those points in your brief, so
right.
I think
Okay, and I am. Let's if I can check my notes here. And I'd argue the last point. There is a kind of a fundamental trying to have it both ways to interveners' arguments. If the subpoenas seek the same information, do in fact seek the same information, then what clearly represents their interests. If the subpoenas do not seek the same information, then there's no prejudice because those issues, there'd be no preclusive effect, either claim or issue preclusion, because the lawsuit would be pursuing a different subject matter, and therefore would no determination in this case would have preclusive effect on Voces' rights. Thank you.
Thank you. Attorney Voiland, you did not file a brief. You simply joined the arguments by Vos and the State Assembly. Do you wish to present anything different from what we've heard so far, or do you stand on your joinder of the Assembly, Defendant Vos and the Assembly's arguments?
Judge, you are entirely correct. We joined the Assembly's briefs and we joined their arguments here today. If you have any questions for me, I'm happy to answer them. A summary, hearing all of the arguments, I think the court.
I don't need a summary of the arguments. I've just heard them. If you have something to add that I haven't heard yet, I'd be happy to hear anything you wish to put on the record.
Judge, I was just ready to say a summary of after hearing all the arguments would be the court's province. So I don't have anything other than to answer any questions that the court would have for me.
Thank you. Attorney Lenz, final word.
Thank you, Your Honor. And I'll be brief. I just want to clarify a few things. First, regarding this distinction between promptness and timeliness, that distinction does not exist in the law. Actually, if you look at In Re Builder, which we cited in our opening brief, bear with me for one moment. Builder versus Delavan Township, 112 Wisconsin, 2nd, 539. In discussing the timeliness requirement under 80309, the court determined that the critical factor is whether the proposed intervener acted promptly. To the extent that Mr. Gableman has conceded that Voces acted promptly and no other party has raised the timeliness issue, I think that's dispositive. I don't think that's really in dispute. Regarding a few other points that the parties have made, I won't go through all of them because I think they're addressed in the briefing, but maybe building off what Mr. Dean was discussing, there's always inherently a tension in intervention, right? If a party shares all of the same arguments as an existing party, they're not an appropriate intervener because adequate representation will never be an issue. Conversely, if a party has too many additional arguments, then it's not sufficiently related. I think what we have here is an overlap in the core issue that's before the court, which is what are the rules that are going to apply to subpoenas as determined by the Wisconsin and the U.S. Constitution. Those issues were squarely presented by the WEC as this court determined on January 10th. And those are the issues that the courts retain jurisdiction over. And that's the exact same question that Voces has. We agree with the defendants that there's nuance because we have different rights from the WEC. We're a private organization that has First Amendment rights and rights under the 14th Amendment that WEC may not have. And we agree that, that there isn't a complete overlap because otherwise, again, there wouldn't be inadequate representation. But to the extent that those things exist, they confirm that WEC can never bring those arguments. WEC is not a private actor, doesn't have the same First Amendment or organizational rights that we do. But those are important for the court's analysis, and they all get to the same question, which is what are the rules for these subpoenas? I will disagree with counsel for the defendants. At least one of the subpoenas is exactly the same as the Voces subpoena, and that's the subpoena directed to Ms. Linsky that's attached as an exhibit to the amended complaint. If the court is going to address certainly issues of overbreadth or burdensomeness of that subpoena, and I think really of any of these subpoenas, the extent that they're requesting the same giant troves of documents and information, Voces shares all of those arguments and all of those concerns that are addressed by the court's consideration of those topics. And that's our core common legal interest. In terms of the counts presented in the complaints, those are laid out. We share 3 of the 4 counts that WEC has brought in both their original and amended complaint. We do have an additional count. There's no dispute about that, but that's the nature of intervention. The party has to bring something new to the table. And in terms of delay, because we have heard a lot about delay from the defendants, Voces did not delay, right? Voces came to court as quickly as they could and are trying to intervene in an expeditious way that will consolidate the decision on these matters. To the extent that the defendants are now concerned about the expiration of the legislative term, this investigation was authorized by the Assembly resolution in March of 2021. They issued their subpoena in December. Voces had no control over that. Frankly, neither did the plaintiffs. And to now hear that delay is so consuming of a problem that it should be balanced against the constitutional rights of both the plaintiffs and the proposed interveners, I don't really know what to say to that. I mean, Any delay has been the result of the actions undertaken by the defendants. Voces and the plaintiffs, I believe, have acted expeditiously in bringing to the court's attention issues that they have, serious issues about the nature of this investigation, these subpoenas. And I'll conclude there and answer any questions the court may have.
All right. Thank you, and I appreciate your arguments. I'm going to make the following decision in order on this motion to intervene. Broadly speaking, a court determines whether an outside entity should intervene in or join an existing lawsuit by striking a balance between allowing the original parties to a lawsuit to conduct and conclude their own lawsuit and allowing others to join a lawsuit in the interest of the speedy and economical resolution of a controversy without rendering the lawsuit fruitlessly complex or unending. Whether to order intervention or joinder turns on judgment calls and fact assessments. And that is a quote from the Helgelin case that the parties have cited today, 2008, Wisconsin 9, at paragraph 6. VDLFA has brought this motion seeking intervention either as of right or with permission. I will first turn to intervention as of right. Section 803.09 sub 1 governing intervention of right provides as follows. Upon timely motion, anyone shall be permitted to intervene in an action when the movant claims an interest relating to the property or transaction, which is the subject of the action, and the movant is so situated that the disposition of the action may, as a practical matter, impair or impede the movant's ability to protect that interest, unless the movant's interest is adequately represented by existing parties. A movant, in this case, VDLFA, must satisfy 4 requirements to intervene as a matter of right. It must show that the motion to intervene is timely, that it claims an interest sufficiently related to the subject of the action, the disposition of the action may, as a practical matter, impair or impede its ability to protect that interest, and that the existing parties do not adequately represent VDLFA's interest. First term to timeliness of the motion. I will find this motion to be timely. I don't see a distinction, as Attorney Dean has referenced, regarding prompt versus timely. Voces filed this motion 11 business days after it received the subpoena on January 5th. To this court's knowledge, nothing else was pending at the time. And to this court's knowledge, which goes to other points of delay that have been discussed here today, to this court's knowledge, discovery has not yet even started on the underlying declaratory and injunction action. Second, VDLFA's interests, the court finds, are directly related to the claims in this case. VDLFA was served with a very similar subpoena as WEC, and constitutional arguments have been asserted. The same defendant, Gableman, served the subpoenas seeking the same or similar information. VDLFA seeks a declaration that the subpoenas are unconstitutional and overly broad, the same claims WEC has made in this case. It makes no sense to this court to expend more judicial resources and more taxpayer dollars to challenge these subpoenas in a separate lawsuit. Given all of their similarities, WEC cannot represent WDFLA's interests, strike that. As to the third prong, WEC cannot represent VDLFA's interests in this case adequately. The standard on this factor is whether the representation may be adequate. The fact that WEC is a state entity and VDLFA is a non-governmental, nonprofit advocacy organization is sufficient enough to meet this burden that WEC may not be able to represent VDLFA's interests. WEC would have no standing to challenge the subpoena. WEC cannot and does not adequately represent VDLFA's interests. Criteria 4, the court finds that the disposition of this case may impair VDLFA's ability to protect its interest. While the court agrees that a decision in this case is not binding authority as a circuit court action, multiple lawsuits could result in inconsistent circuit court decisions on the same issue of the validity and constitutionality of the subpoenas, which does not at all support does not at all support a judicial economy argument and is a waste of taxpayer dollars and judicial resources when the same or similar subpoenas issued by the same defendant are challenged in separate lawsuits. So the court will find that VDLFA meets the criteria for intervention as of right. Even if VDLFA did not meet the criteria for intervention as of right, it still meets the criteria for permissive intervention. Section 80309 sub 2 provides in relevant part, upon timely motion, anyone may be permitted to intervene in an action when a movant's claim or defense and the main action have a question of law or fact in common. In exercising its discretion, the court shall consider whether the intervention will unduly delay or prejudice the adjudication of the rights of the original parties. As the text of Section 80309 sub 2 itself makes clear, the circuit court has discretion to decide whether a movant may be permitted to intervene when the movant's claim or defense and the main action have a question of law or fact in common. The appellate court in this instance will not disturb a circuit court's discretionary decision so long as the record reflects the circuit court's reasoned application of the appropriate legal standard to the relevant facts in this case. The Vos defendants argue that VDLFA should not be allowed to permissibly intervene in this case because VDLFA could protect its rights by filing its own action, as also that position was joined by Special Counsel Gableman, or even intervening in the Waukesha County case that is pending. Vos acknowledges the risk of conflicting judicial opinions at page 8 of his brief and urges this court to deny VDLFA's motion, quote, out of respect for the Waukesha County Circuit Court, end quote. WEC filed this action in Dane County on October 21st, 2021. Gableman filed the Waukesha County action on December 2nd, 2021, without referencing the Dane County lawsuit challenging the validity of his subpoenas that are at issue in the Waukesha County case. This court believes that if any deference is due in considering the risk of conflicting judicial opinions, it should be due to this court, given the timing of the filings of the Dane County and Waukesha County lawsuits and the underlying challenge in this case to the validity and constitutionality of those subpoenas. As to the specific criteria for permissive intervention, VDLFA's claims and WEC's claims have a question of fact and law in common. The subpoenas are virtually identical. Both WEC and VDLFA claim the subpoenas are unconstitutional and infringe on constitutional rights that deserve protection by this court, in spite of any deadlines the legislature seeks to impose on this claim. VDLFA's lawsuit, if filed separately, would name the identical defendants, alleging similar constitutional claims and requesting the same declaratory and injunctive relief as WEC is seeking in this case. Under either permissive intervention or intervention as of right, VDLFA has met the criteria for intervention. Given the shared issues of law and fact between WEC and VDLFA, the constitutional challenges to the same or very similar subpoenas seeking the same or very similar information, and the same defendants, it makes absolutely no sense to deny this motion and permit extra judicial resources and taxpayer dollars to be spent on the filing of yet another lawsuit regarding the constitutionality and validity of these subpoenas. The court will grant this motion. Attorney Lenz, will you please prepare an order for me to sign? It does not have to be detailed, simply for reasons stated on the record.
Yes, Your Honor, thank you.
With that, we have a motion that was filed after the intervention motion was filed regarding an amendment to the complaint. As the parties know, the rules of civil procedure state you can amend a complaint as a matter of right within 6 months of the filing of a lawsuit, but there has been a formal motion filed. Attorney Burnett, do you wish the opportunity to respond and object to the motion to amend and supplement complaint? You're on mute.
I wish to reserve the opportunity to respond. I don't know if I will object yet or not, Your Honor. I need to discuss the matter with my clients.
Okay, can you let me know within 1 week if you wish to object so that I can get this matter on for hearing.
Ken.
Attorney Dean?
Yes, I would echo Mr. Burnett, 1 week to confer with clients and advise the court whether we would request opportunity to object.
Attorney Boylan?
Judge will be joining the legislature's decision.
All right. So by February 9th, I would like a response from you. It can be a letter form is fine. Just asking this court to set this matter for further hearing on the motion. And if you do not object, then Attorney Johnson Karp, you may just simply file an order granting your motion if there is no objection by the parties by February 9th. Okay?
Thank you, Your Honor.
All right. Anything further today, Attorney Johnson Karp?
Nothing from the state plaintiffs, Your Honor.
Attorney Burnett?
Just with regard to the answer in response to the intervener's complaint, which I assume is going to be filed, my understanding would be it would be a 45-day response period, but I haven't checked the statute on that. Does the court have any indication as to when it expects to see an answer?
Follow the statutory guideline. I haven't looked at that issue specifically for today. If you wish to, I mean, obviously you could file it at any point. It doesn't have to be on the deadline, but
Okay.
whatever your timeline is appropriate for this action.
Thank you.
Attorney Dean, anything else today?
No, Your Honor. Thank you.
Attorney Boyland?
Have a good day, Judge. Thank you.
Thank you. Attorney Lenz?
Nothing further, Your Honor. Thank you.
Thank you all. We're adjourned.